dereliction of duty. The United States Supreme Court fails to decide two major Second Amendment cases. Is it the end of the right to keep and bear arms in America? Stay tuned. We're going to break it all down for you. Hey guys, Marc J. Victor here with Joey Hamby. For the first time, Joey and I get to make a video together. We're going to talk about and break down these two terrible moves by the United States Supreme Court. But you know what? First, I want to say welcome Joey Hamby to the firm. I know you've already done some other videos out there, Joey, but I feel like I should say something right here at the beginning. And just to let everybody know, Joey didn't just wander on into our law firm here. I've known Joey Hamby for over 30 years. We were both young whippersnapper attorneys way back when the earth was cooling. And I can remember really specifically, I don't know if you remember this, Joey, but sitting in the back of a courtroom in a state case, both of us just wasting away, waiting for the judge to call our respective cases on the morning calendar. You know, and I'm always looking for trouble, so I always want to start in with other criminal defense lawyers, find out who's pro-freedom and who's not. And I think you and I were just sitting next to each other. And so I started in, and to my surprise, I thought, you know, this guy's really pro-freedom on all issues. Do you remember that conversation?
I do. It was a very fun time, Mark. So first of all, thank you very much for having me here. But I'm really sad that we have to be together on these two cases.
Yeah.
So, but like you said, I really remember back in those days, again, over 30 years ago, it was so much fun. That was a great time to meet another defense attorney. I tell you, many people think that defense attorneys are all liberals and they're all cut from the same cloth. I tell people all the time, if you're a defense attorney, you should be pro-freedom, more conservative than liberal, quite frankly, from my perspective. And I was very happy to meet a kindred spirit those years ago.
Yeah, I was so disappointed. You know, I remember coming out of law school thinking every criminal defense lawyer is going to be pro-freedom. And so many of them were really pro-government. I was very disappointed. And so when I met you, I was very enthused. And I've been watching you throughout the 3 decades we've been practicing. And I thought to myself, I'd really like to get Joey Hamby over to our law firm. Here's a guy who's been trying major felony cases, who's very, very pro-Second Amendment. And it wasn't until fairly recently that we were able to put a deal together. And it warms my heart to have you here at our law firm, to have you on our team, and to have you available to represent all of our AOR clients in every case. Because as people know who've been paying attention here, every lawyer on the team, every lawyer at the firm represents every AOR client. We all work together on these cases. So anyway, it's an honor to have you here at the firm. But yeah, it's a bit of a downer to have you here for the first video that you and I are doing together to talk about these two ridiculous moves that the United States Supreme Court just made. But you know, I also want to say, I know a lot of people in the Second Amendment community are really upset about this case, and they think it's the end of the world. It's not the end of the world.
Yeah.
This is a setback. There's no doubt about that. We think the court should have taken action here. But look, folks, keep it in perspective, right? We still live in the best place in the entire world to live. Yes, both of these cases, they didn't actually go the wrong way. The Supreme Court just denied cert, which means they refused to look at them, and which leaves them in a posture the wrong way. But this isn't the end of the story. This is a bump in the road on the fight for freedom. And, you know, I wore my Gadsden flag tie today, right here, just to remind everybody the fight for freedom is ongoing.
With the Marine Corps pin.
With the Marine Corps pin. It's been a fight, right?
Yep.
The tree of liberty must be refreshed from time to time with the blood of tyrants
and patriots,
right? It's an ongoing fight. And so we took a couple of blows on the chin here because the Supreme Court that really should have taken both of these cases and smashed both of these crazy left-wing anti-Second Amendment courts. They didn't. But of course, there are reasons for that. What are your thoughts, Joey?
So a couple things. One very large global takeaway, though, I want for our viewers and our members to understand. You don't rely on the courts in the end to protect your freedoms. The folks in Maryland, unfortunately, have a legislature that they put in place that put this law in place that the federal courts have upheld. If you live in another state, those other states have different laws, and frankly, you can still possess the very same things that in Maryland you can't possess, or in Rhode Island that you can't possess. So I think the takeaway for our members, our viewers, is go to the ballot box and protect your rights individually. However, if you're relying on just the courts to do it, here's where you end up many times.
Yeah, I mean, we're supposed to have a government of checks and balances. And so when the legislature goes awry and passes laws that violate the Constitution, here specifically the Second Amendment, that's the main job of the court. I mean, in the Federalist Papers, I think it was Madison who talks about the court, the Supreme Court, is supposed to be the watchdog of the legislature. So when the legislature, which is subject to the whims of people, and oh my God, there's these shootings and horrible things are happening, we got to ban guns, that the court, the people who are appointed for life, the people who are in charge of guarding the Constitution, they were supposed to strike this stuff down, and they blew it. Of course, we're talking about Snope v. Brown, the case out of Maryland, and the Ocean State Tactical versus the state of Rhode Island, obviously out of Rhode Island. The Snope case is the one where Maryland just decided we're going to ban a whole bunch of weapons.
Yeah, they listed 45 specific guns, although really they're not specific guns. They're guns and then whole categories of guns, as well as any copies of those guns, no matter who makes those. I have no idea how many tens or hundreds of thousands of firearms in the state of Maryland have been regulated out of existence, have been outlawed by that statute. So it's a very broad statute.
Yeah, I mean, we talk about it as really the AR-15, which is really one of the most popular, in fact, the most popular long gun in America. That's certainly on the list. It's hard to believe that in America, if you're in Maryland right now, you can't have an AR-15, even though we've got a Second Amendment that specifically protects your right to keep and bear arms. That's shocking, and the Supreme Court just left that situation alone in Maryland. And then the other case, the Ocean State Tactical, where Rhode Island, in their great wisdom, decided, 10-round magazines, okay, but 11, oh, you can't have that. Anything more than 10, well, this is a giant problem. And so they have banned magazines that hold more than 10 rounds, which of course are so many. Most magazines in these weapons hold more than 10 rounds. And anybody who uses these weapons, and I certainly did quite a bit in the Marine Corps, you press a button and pop out the mag, and you take the next mag out of your pocket, which is fully loaded with 20 or 30, and you pop it in, and you're pretty much ready to go at that point. You pull the bolt back and you're good to go. This is a 2 or 3 second project. This isn't going to solve anything for these mass shootings. We know that. But, pulling this back for a second to go to the 30,000-foot view, there are two debates that I think we need to keep in mind here when we're talking about these kinds of issues. There's first the big debate, the one that we need to have in America, which is, why do we have the government at all? What is the role of government? And whether people realize it or not, this is the big debate that we're having in America. Nobody's talking about it in these terms, but there's one side, our side, the freedom side, that says the purpose of government is to act as our agent to protect our rights, the rights that we already have. We don't get them from government. We form the government. We then defer some of our authority to them for the sole purpose of protecting our rights. Now, that was the position of the people who fought in the Revolutionary War. That was the position of the framers of the Constitution. That's always been the American position. Then you have the other position, which is quite popular today, which is, no. The purpose of the government is to, right the wrongs of society, redistribute wealth, to take care of people from cradle to grave, to make your life better. I mean, that all sounds great, and I know people sort of buy into it, but it never works out like that, and it results in violating people's rights. We got to win this argument, and we're not having the explicit debate on this point, and I hope people watching or listening to this video will sort of crystallize that in their head and start having this kind of debate. What is the purpose of government? And then the second debate, which I think you see if you read the cases here, it used to be the debate that was raging when you and I were in law school, Joey, which was, What does the Second Amendment mean? And our side always said, well, look, it's an individual right to keep and bear arms. It talks about the people. It's the same people that the other amendments talk about. Of course, the people are individuals. And the other side said, no. It's essentially the right of the state to have a National Guard. It's a collective right. We won that argument in Heller. That's not the debate in this case. But now, as I see it, to frame the debate, at least from reading these cases, the debate here is now about, is the Second Amendment, the individual right to keep and bear arms, is it really just about individual right to self-defense, right? And this is essentially what they're talking about in the Snope case. You don't need a 50 caliber. You don't need an AR-15. And of course, you know, I talked about this earlier today.
Yeah.
I think you can make a good argument. An AR-15 is a good weapon for home defense, especially if you don't want to wait for somebody to come within 10, 15 feet of you. But a 50 caliber, you got a little bit of a tougher argument there. But is it just about the right of an individual to self-defense, or is the Second Amendment there so we can defend against a tyrannical government, either our own or another one? It seems pretty clear to me that's the debate we got to win at this point. What are your thoughts on that, Joey?
So I agree. And yes, going back to over 30, 35 years ago, I remember well having these very raucous debates in law school, and every constitutional law professor seemed to be on the collective rights side of the argument. I felt like a voice in the wilderness saying, no, this is an individual right. The First Amendment is an individual right.
Every other right. Yeah.
Every other right. Every law professor would agree those are individual rights. And it comes to this one, well, no, this is a collective right because we've got this conditional precedent modifier. It was ridiculous. You were trying to use grammar to argue that this was not a individual right or an individual right. So I absolutely agree that we've got a huge debate. You can see our country is pretty much split down the middle between people who think that government should be there to essentially protect us all and make everything equal and help everybody out, as opposed to protect your rights and let you help yourself. So I agree that's a very fundamental issue that we've got going on. With regards to these cases, I think that's where the rubber meets the road in how you view things, either collectively or individually. With regards to the Snope case and the AR-15 in particular, I agree that what they're trying to do is take Heller and Bruin and bend them so that it only goes for home defense or self-defense against another individual. But think about this. Think about when the Constitution was written and how soon after a revolution against a tyrannical government this was written.
Yeah.
And do you think that the framers were thinking only of self-defense? Of course not. No, they were thinking of the situation they had just been through where, but for having the ability to defend themselves against a tyrannical government, they would still be under the boot heel of a tyrannical government. So I absolutely agree that this is not just about your right to defend yourself against another individual, but your right to defend yourself against another large group of folks, whether it's a military, an invading force, whatever it is.
Yeah, this is why the Second Amendment doesn't talk, about a militia being necessary to have to be a free person. It's about a free state, right? You get to defend against a tyrannical government. And, people think that just because we haven't had this issue in quite a while, that we'll never have this issue. And, I'm reminded about this. My wife, some people know, was born in a third world country. She's from Myanmar. And Myanmar is one of those countries that specifically banned the people from having firearms. So when the military a few years back marched in, arrested the civilian members of the government, threw them in prison, and said, we're now in charge, and we're going to rule with an iron fist, the people had no way to resist the tyrannical government. My wife tells me there were people up in the mountains who illegally had weapons, and now those are the ones charged with sort of fighting this tyrannical government. But this is the fear that the founders of our country had. It was about the government going awry. If you read anything that they have written, they were afraid of government. They didn't trust. That's the reason for the separation of powers. That's the reason for checks and balances. We do not trust the government, and we do not trust the government to not become tyrannical. And, I think what Maryland did, and look, I think the people there acted in what they thought was best, but to tell competent, responsible firearms owners, millions, tens of millions of whom have peacefully kept AR-15s and committed no crimes, that none of you can have these weapons, that seems pretty tyrannical to me.
Yeah, I want to also focus on one of the things that the court in Snope said, to just kind of hone in on that, which is one of the things that the court said was when they were dealing with AR-15s, they said, well, these these don't really seem suited to self-defense or to home defense. They seem more suited to criminals in the military. And I read that and I thought, I can't have read that. I had to read it again. I'm like, so it's okay for the court to say, well, the criminals can have these weapons or the military can have these weapons, but you as citizens of a free country can't possess those for defense against the criminals or defense against, if you had to, an overreaching military. And let's be really clear with our viewers, with our listeners, with our members. We're not sitting here saying, take up arms against the government. Absolutely not. We live in the best country in the world, as Mark was saying. But part of living in that country is having the ability to defend yourself, not just against somebody invading your home on an individual level, but against the threat of a military, against the threat of an overreaching government. That's part of living in a free society. It's not just voting. It's doing all the different things that we have to do as citizens, and that includes protecting ourselves. So, I think that the court here really is derelict in its duty. First off, the circuit court, and then unfortunately the Supreme Court, in not taking this up, in denying cert or denying the appeal essentially from the lower court.
Yeah, if you read the Fourth Circuit case, what you find is they analyze this as an individual right to self-defense and essentially say, look, the AR-15, these 50 calibers, you don't need these for self-defense. And in the other case, the one out of Rhode Island, you don't need more than 10 rounds. It's very rare that somebody uses more than 10 rounds in self-defense. Again, that's the argument. It's not about resisting a tyrannical government. It's about individual right to self-defense. And the Supreme Court needs to clarify this. We just missed on Snope, right? You need 4 votes to take the case. We got Alito, we got Gorsuch, we got Thomas. And shockingly, Kavanaugh, who I think very clearly signaled that this is unconstitutional. If you read what Kavanaugh wrote, in fact, I'm gonna read from the case. Here's what Kavanaugh wrote in agreeing that, nope, we're not going to take this case. Here's what he said. For their part, criminals use both AR-15s and handguns, as well as a variety of other lawful weapons and products in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America. In short, under this court's precedents, the Fourth Circuit's decision is questionable. Although the court today denies certiorari, a denial of certiorari does not mean that the court agrees with a lower court decision or that the issue is not worthy of review. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeal. Then he goes off and 1, 2, 3, 4, 5, like about 5 different cases, all pending on this issue. Of course, they're all in the liberal states, right? And then he continues in saying, in his agreeing of not taking this case, he says, additional petitions for certiorari will likely be before this court shortly. And in my view, this court should and presumably will address the AR-15 issue soon in the next term or 2. Okay, so that's what Kavanaugh says. I think you don't have to read very far into that to come away from that with the conclusion. Kavanaugh agrees with Alito, Gorsuch, and Thomas. So they got 4 votes that this rule that Maryland put in, simply banning all these long guns, including AR-15s, is unconstitutional. If you read a little bit deeper in between the lines, you say, what happened with Roberts and Barrett? You got the other 2 conservatives on the court. You don't hear a peep out of them on this case, but you got to believe they had a discussion with those 2. And if one of those 2 had said, you know what, I agree, we should take this case and reverse this, they definitely would have taken this case. So I think we can conclude from this, for some reason, it may be a decent reason or an understandable reason, I'm not saying I agree with it, maybe Barrett or Roberts said, look, we got all these other cases pending, let's let the other circuits reason through this. Maybe 1 or 2 of them will come up with the right decision here. That would be nice to have that. I think they are going to take this issue up very soon, right? Barring something unforeseen happening. Somebody could die, anything could happen. But I think they will take this issue up soon, and they will do the right thing. They will reverse Maryland's ban, and of course, by that time, other states, and there are other states that ban these right now. I think this issue is going to be fixed in the long run. But you know what? To hell with everybody who can't have an AR-15 right now in Maryland and other places. And all the money that was spent on bringing this and all the effort, they just swatted it down. I think this is dereliction of duty. I think they should have taken it. They should have issued a ruling. And if you can't get Barrett and Roberts on board right now, let them go out there and explain themselves. You can always take another case and find a different ruling if you can convince those guys later on. That's what I see reading between the lines here. What are your thoughts, Joey?
No, I agree, absolutely. And I hear everything that you're saying about Kavanaugh. And I'm going to tell you the people who read the tea leaves at the Supreme Court are saying what Kavanaugh's really saying here is we don't have the votes that we need right now. There's going to be another case coming along where we can get these votes, have patience, and another term or two. I'm worried about another term or two, quite frankly, because you know the way things are going in the political sphere. I don't know that we have another term or two. I hope we do. I'm more on your side where I think this is going to get fixed. I think it's going to get worked out correctly. On the other hand, I feel like Justice Kavanaugh is writing some pretty big checks. I don't know if he has the ability to cash them.
Yeah, and to be fair, really what should happen, in my opinion, right now is the older justices. I'm thinking Thomas, I'm thinking Alito. Now is the time, right? You're not going to be on this court forever. You got to step down right now where there's at least a chance to get another pro-Second Amendment, maybe pro-freedom justice appointed and confirmed, because there's a real chance that you lose the Senate here in the midterms, and this could be much harder down the road. Now's the time. If you're Thomas, you got to be thinking, I mean, look, as much as Thomas's decision, in fact, we should talk about some of the things that Thomas said here. Thomas's decision was absolutely fantastic here.
Spot on.
Yeah, there were lots of quotes I wanted to go through. Maybe I'll just go through a few of them and we can put them up on the screen as I'm reading them. Thomas says, for starters, it is difficult to see how Maryland's categorical prohibition on AR-15s passes muster under this framework. To start, AR-15s are clearly arms under the Second Amendment's plain text, period. He also goes on and it says, explaining that arms include anything that a man wears for his defense or takes into his hands or uses in wrath to cast at or strike another. Thus, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. After a bunch of cases, AR-15s fall squarely within this category. He says later, but I am not aware of any historical regulation that could serve as a proper analog to Maryland's ban. Under this tradition, however, a weapon may not be banned unless it is both dangerous and unusual. And I just pause on that. You know, an analog here that you might think about is the Eighth Amendment's prohibition on cruel and unusual punishment, right? And I remember as a young lawyer, I'm thinking, this is cruel. This is horrible, cruel punishment. Yeah, but unless it's also unusual, right? It can be unusual. If it's not cruel, then it doesn't violate the Eighth Amendment. They're very clear. It has to be cruel and unusual. And so really, these are arms that, again, the AR-15, the most common long gun in existence that free citizens in the United States possess. Hard to see. Yeah, hard to see how this fits.
And to break down what Justice Thomas was saying there, this is an argument that I remember, again, from over 30 years ago with our constitutional law professors who would say, okay, let's say that it is an individual right, not a collective right. Well, if it's an individual right and you're such an originalist, then it's an individual right to own the type of firearm they had there. So go ahead and have all of the muzzle loaders that you want.
Yeah.
Right? But Justice Thomas is saying, no, come on, be realistic here. It is an individual right to carry commonly owned and used firearms. And there isn't a more commonly owned and used long arm than the AR-15. There just isn't.
Right. This is an unusual weapon? Come on. And imagine that logic extended to the Fourth Amendment, right? Search and seizure law. Well, there weren't any vehicles at the time that the Fourth Amendment was adopted, so there must be no protection for a search or seizure of your vehicle. I mean, this is ridiculous, right? This argument, if you apply it consistently, is absolutely ridiculous. He says a prohibition of an entire class of arms that is overwhelmingly chosen by American society for these lawful purposes falls outside the government's power. And then he ends up, a couple of quotes here to end up, this reasoning is dubious at least twice over. The Fourth Circuit placed too high a burden on the challengers to show that the Second Amendment presumptively protected their conduct, and its determination that AR-15s are dangerous and unusual does not withstand scrutiny. He also says the Fourth Circuit placed the burden of producing historical evidence on the wrong party. That's absolutely true.
Absolutely correct.
Yeah. Actually, I got one more here that I wanted to read that I thought was excellent. Our Constitution allows the American people, not the government, to decide which weapons are useful for self-defense. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all.
Yeah. So when I read Justice Thomas's opinion, it just leaped in my mind when he said it was constitutionally questionable twice over. I thought this is like the Fourth Circuit's twice-baked potato of unconstitutionality. First, they're saying that an AR-15 is not an arm, which is just patently ridiculous. And secondly, they're saying even if it is an arm, it's your job as the citizen to carry the burden of proof to show that it shouldn't be regulated, instead of putting the burden of proof back on the government where it belongs. This is as if you showed up in court for your trial. You've been accused by the government, falsely accused of a crime. You show up and they say, I know there's the Constitution that says it's the government's job to prove that you're guilty beyond a reasonable doubt. But here in our state, we've passed a law that says it's your job to prove that you're not guilty.
Yeah,
That's what they did.
I think for the Second Amendment junkies out there, read what Thomas wrote in this case. It's really stunning. You won't be confused about what Thomas's position on this. I think this is very well done. And unfortunately, he just didn't have the votes to get this case taken up. We don't know why. But I am going to go on record, as I have already done, I suppose, and say this is going to be fixed down the road. So this is a problem at the moment, but it's not the end of the world. I predict this is going to be fixed, and probably the very next opportunity they get to take it. We'll see what Barrett and Roberts have to say on this case. That's really the big question that maybe people aren't talking about in this case because you don't see anything written by them there. But the problem resides with at least one, and maybe both, of those two justices.
Yeah, no, I agree. Those are the folks that we've really got to worry about at this time. There's no question where Thomas is, of course. No question where Alito is. No question where Kavanaugh is. We're simply sitting here saying, where are Roberts and where's Barrett?
Yeah, and the other case out of the First Circuit, the Ocean State Tactical, you see exactly the same problems there, the burden shifting, putting the burden on in the wrong place.
And the same breakdown.
Yeah. You know, also one other thing, these, in my opinion, the First Circuit in the Ocean State case is still kind of operating under the old scheme of balancing interests here, right? Before we got the Bruin test where, you know, courts would sort of balance, how about they talk about this really isn't very big of a burden on the rights. Okay, that is not the right analysis right now. It's a historical test post-Bruin. I think they just applied the wrong test here. So it's a real shame. Again, Alito, Gorsuch, Thomas would have granted the petition in the case out of Rhode Island, the Ocean State Tactical case. But again, not Kavanaugh. We don't know about Barrett and Roberts there too. So the Supreme Court's got to get its act together here. Your job is to be the guardian of the Constitution. And whether you like it or not, the Second Amendment is part of the Constitution. And, you know, Thomas makes that point in the Maryland case right at the end. He says, if this was any other right, we wouldn't just sit by idly and do nothing when a state so blatantly violates the constitutional right here to keep and bear arms. You know, if they were just sort of banning free speech or they did something with the Fourth Amendment or any of the other individual rights, the court would be all over it. I know that some other commentators have made the observation that when it comes to, you know, immigration and other things going on, the court acts very quickly. Here, Second Amendment, the redheaded stepchild of the Constitution. We thought this was not going to be a problem going forward. We had 3 Republican, in fact, Trump appointed and confirmed justices, Barrett and Kavanaugh. This was your time to shine, and you both blew it, in my opinion. But hopefully they'll redeem themselves. Hopefully very soon. This needs to be fixed.
Yes, very much so.
All right, so there's our overview of these 2 horrible cases. But this story is not the end of the story, right? This is a chapter. We lost a battle here. We haven't lost the war. I think we are going to win this war on these particular issues. very soon. At least I hope so. That's where I'd be betting my money. And so this has been Marc Victor and Joey Hamby. We hope you liked our breakdown of both of these cases, but read them for yourself. They're a little bit long. If you want to dive into them yourself, feel free. It's interesting stuff. You can see how our government works, or in this case, fails to work. If you guys like this video, if you want to see more videos like this, just put that in the comments below. We do review every single comment on our videos. Let us know what it is you guys want us to do to keep you posted on your rights. If you want to know about the Attorneys on Retainer program, the best damn program in the United States, if you're a firearms owner and what you're worried about, you're going to act in self-defense and still get charged with a crime, and you want the only law firm in the entire nation that does nothing but self-defense on your team, every lawyer at the firm on your team, check out attorneysonretainer.us. You want to know more about that hardcore pro-freedom, self-defense only law firm, the only one in the nation, check out attorneysforfreedom.com. Don't forget to like, comment, subscribe, share this video. It really helps the channel grow, and we appreciate you doing that. All right, Marc Victor and Joey Hamby signing out. Peace.